So Matt and I are going to jump in here and give you a bit of an update about Morgan. So for those of you that are new to the anti-captivity world, you may not have heard about Morgan. Just be careful, Matt, so those guys can see. Thank you. So I just wanted to explain a little bit about her and where she is. This is Morgan, a photograph of her from some of her self-harming, from the injuries of removing her skin. The yellowing is the hypertrophic tissue damage from continually banging against the side of the concrete tank. She's in Loro Parque in Spain. She was owned by SeaWorld, and while she was owned by SeaWorld, during their period of the breeding ban, she got pregnant. And so SeaWorld was so horrified about this, they divested their interest in her and the other whales that they had at the time to the owner of Loro Parque, who is a German. Morgan was born in Norway and captured by the Dutch. So you can't get much more of a more complicated story about following her around, but if you want to see more about her, please go to freemorgan.org. But I just wanted to point out to you a little bit about what's going on at Loro Parque. So currently there are 4 orca there. So 3 captive borns, which were born all in the United States, and Morgan. But it's worth keeping in mind of what was at Loro Parque as well. So these are the deaths from 2013 to 2022. So Skylar died at only 17 years old. Kohana, the mother of Victoria, died at 20 years old, and Victoria only at 10 months old. And then Morgan's calf, Ula, died as well. And you'll see that the father is Quito. And Quito, for those of you that have seen Blackfish, is the orca that killed Alexis Martinez. Now, in no other industry working with animals do you breed killers, right? It's not that he's going to pass on the genetics, it's just not ethically and morally right, but Loro Parque doesn't care about that. So if you want to read more about some of the things that are going on that Matt's going to talk about now, this is the history of it in this paper. And from there, I'll go on and let Matt give you the updates.
So last time we were here, 2018, we had just returned from presenting our first petition to the European Parliament. It came on the heels of our white paper and Morgan's Law that we were proposing. And here we are, just finished telling the European Parliament Petitions Committee why they needed to take action on Morgan. In the interim, after we were here at Superpod, we did this Mission Creek paper with Arie Trouwburst, who's from the Netherlands and does extensive environmental work, and he's written multiple peer-reviewed papers on Morgan, so we were kind of honored to join with him in this paper. Morgan, like I said, might not get much news around here, but she's still very relevant in Europe. Zeit magazine in Germany did an incredible expose. It made the cover of the magazine. What would the orca want? And this journalist had a good insight and got to meet with Kiesling, the owner of Loro Park, and did a lot of important information that we used in further arguments we've been making. We also did a paper with our colleague Natalie Barefoot, Wildlife Conservation and Public Relations, the greenwashing of marine mammal captivity. A lot of examples. It's a good paper. Also talks about how Morgan fell into the captive exploitation. And in 2021, a Dutch program called Zembla, it's sort of like a 60 minutes frontline, very investigative expose of Morgan. They were celebrating the 10-year anniversary of Morgan's capture in the Netherlands. Normally they do a one show. They did a 2-night expose on Morgan. They also had access into Loro Park. Got some interesting responses from, Brad Andrews, who basically oversaw all of Morgan's transfer from Loro Park, or from Dolphin Park into Loro Park. At the very end, they got questioned about, well, SeaWorld owned Morgan, because they've always denied it. And Brad sort of hemmed and hawed and goes, well, technically on paper. And the journalist goes, well, paper counts, doesn't it? He goes, yes. So we finally got someone from a former SeaWorld official to actually acknowledge everything we have already known, that SeaWorld acquired the ownership interest of Morgan before she got to Lower Park. So once again, a few weeks before coming to Superpod, we were back at the European Parliament. Naomi was there, Margot, Muriel, as part of the Dolphin Area Free Europe. And we were just making the case, trying to let MEPs and members of the commission who might have been listening what's going on. Our presentation, or my presentation, was, again, detailing what you're going to hear today, which is our efforts to work within the EU system and try and get basically the EU law that should be protecting Morgan to actually protect her. This was MEP Francisco Guerrero who hosted the event, and I think we're going to expect some good follow-up from him. So briefly, in the EU, there's a couple of classifications of how the animals are protected. And the highest protection goes to an Annex A specimen, which would be a wild-born specimen. And Annex B would be a captive-born, like the other specimens in the parks presently. So Morgan is the only Annex A orca in captivity in the EU. So she's supposed to be receiving the highest protections. She's regulated by Council Regulation 33897. And it's very clear: display to the public for commercial purposes, use for commercial gain of the specimens of the species listed in Annex A shall be prohibited, full stop. But like everything with a full stop, there's always the possibility of an exemption. So exemptions from those prohibitions can be granted. They have to be done on a case-by-case basis, and they're supposed to be the exception, not the rule. So in Morgan's case, there are three possible exceptions that could have been granted. One was for the advancement of science. So in this long process, we've been working to try and get the European Commission, which is sort of the overseer of all the administration of the EU law, to acknowledge that things aren't what Laura Clark and Dolphin and Hardove has said. So we've asked the Commission about whether Laura Park is a scientific institution. They acknowledge that they're not aware of Laura Park Zoo having been requested to be a scientific institution. It has significance for how the law is applied. Another exemption is that if the specimens are going to be used for breeding, propagation, from which conservation benefits will accrue to the species concerned. Well, Morgan's the only Annex A. She's housed with 3 males presently. They're all Annex B. Any calf Morgan gives birth to will be an Annex B. It'd be unreleasable, have no benefit to any of the species out in the wild. The Commission always likes to just skirt around issues, so we were asked through a series of questions to comment on whether they're aware of any conservation benefits for Orcinus orca accruing for such programs such as the ones at Laurel Park. And they just don't want to answer that. So they're not in a position to judge, and they absolutely are. The third exemption, and this is what actually was used to allow Morgan to get transferred from the Netherlands, was that she's intended for research or education, preservation or conservation of the species. In all of these exemptions, the predominant use has to be that exemption. You can't predominantly use the animal for commercial purposes and do one experiment in 1 year. It really has to be predominantly, this is why the animal is there, and incidental to that, she could be displayed to the public. So when the Netherlands issued the permit to let Morgan go, they were very specific on the condition that she only be kept for research. So EU law, as we read it, and it's supposed to be applied, prohibits Lower Park from using Morgan for primarily commercial purposes. Even if they had a permit exempting them for one of these uses, if it was primarily being used for commercial purposes, that would be in violation of EU law. So about a year after Morgan had arrived at Lower Park, she got into a show somehow. And someone called them out on it, apparently, because Lower Park put together a several-minute video with the then head trainer, Miguel Diaz. And I didn't have the live video, but in a couple minutes' time, this is what he was saying to try and explain why Morgan was in the show, and we don't want a trainer to be in the show. She's not in the shows, not here to train to be in the shows. And he kept saying it's very important to understand. This was just, she just got in the gate She wasn't supposed to be there. Yet in 2012, there's Morgan headlining shows. She's highlighted in the light spot, and has been on the shows ever since. May 2023, the last visit Ingrid had to Laurel Park. She is the featured performer on the jumbotrons, in the commercials and the advertising. She is the most exploited commercially used orca in the EU. So we've been trying to make our case for at least the last 5 years with the European Commission to try and get them to engage with the member states who, through their management authorities or the CITES management authorities, are supposed to be regulating compliance with the regulation and the permit that was issued to Morgan. And they keep saying they will always attach, stress full compliance with the EU wildlife trade regulations. And it's not just us, but it's interesting that the response that we've received and members of Parliament have received is that the Commission always says it will examine any well-funded and substantiated evidence that is brought to its attention. And that little line is not just for Regulation 33897, but apparently MEPs get that response from the Commission anytime the Commission just doesn't want to be responsive to the politicians or individuals trying to accomplish something, because they can recite that at will and yes, that's what they told us too. So in Morgan's case, anyone who's read any of our papers, like the white paper, knows we've been very diligent in our advocacy. We extensively document our arguments. They're well-founded and substantiated in evidence. And we have made the Commission very well aware. We've made member state of Spain very aware, and even the Netherlands government aware of the failures to implement the law in terms of Morgan's permit. So just a quick overview. When we started this, 2015, our white paper was submitted to the CITES Secretariat, the European Commission, and the U.S. Marine Mammal Commission. That sort of started our dialogue in Europe with the European Commission. When we didn't get an adequate response from the European Commission, we did our first petition to the European Parliament. When we didn't get the Parliament closed that based on comments and discussion provided by the Commission, which omitted a big part of our paper and omitted the whole separate issue that we were arguing as well. So we meant to make a complaint to the European Ombudsman about the Commission's failure. Excuse me. Okay. So when the European Ombudsman didn't take our case seriously, we then requested the Petitions Committee of the Parliament to reopen our petition. And that turned into a new petition, which came and went without any good resolution for us as well. So that brings us to where we're back at the issue of this piece of paper, and you turn it both sides. This is one piece of paper. This is what controls everything about Morgan at Laurel Park.
And everything we've done for the last 10 years is this one piece of paper.
And it's really the front page. And it's even less than that, because we're going to talk about what this is. But there's two ways this certificate could have been issued for Morgan. A transaction-specific certificate, which is how this one was issued, and a specimen-specific certificate. Specimen-specific certificates are issued one time by any member state in the EU, and they will follow the animal anywhere. So if one country grants an exemption, it's going to stay that Morgan could be used for commercial purposes no matter where she went. They didn't do that. The Netherlands government issued it as a transaction-specific certificate. And on this one piece of paper, the front page, there's a couple of boxes. Box 1 at the very top, which identifies the holder. That's who the certificate and any exemptions are granted to. It explicitly states it's Delphinarium Harderwijk in the Netherlands. So box 20 then sort of expounds on that. And this is, again, the check mark is box 20. It shows it's a single transfer only, one movement from the Netherlands to Spain. And with the X down at the bottom, it just says, again, its certificate is valid only for the holder named in box 1. So everything you need to know about who's entitled to the exemptions under this is on this front page. So this was an intentional decision by the Netherlands government. They wanted to add scrutiny and protection to Morgan and restrict any unscrupulous commercial exploitation by passing her from park to park or using her for other things, and requiring basically Laurel Park to get their own exemption if they wanted. So this certificate, even box 2, lists the location where Morgan is supposed to be kept, and we're not going to dispute that that's what the Dutch government intended. That is listed as Laurel Park, but that's just a street address. It's not, they also are entitled to part of these exemptions. Only Laurel Park was granted or Dolphin and Hardick was granted the exemptions. So right now, Laurel Park can legally, based on the Dutch government's decision, hold Morgan. She's supposed to be there with other orca, as Miguel Diaz was saying. She's not supposed to be in shows. She was just there to be with fellow orca. So again, we've got box 1 and box 20, making it very clear that Hardick holds any exemptions, not Laurel Park. Problem is the Spanish government seems to be disregarding this very clear statement on the certificate. So when we had our petition to the Parliament first time, the Petitions Committee requested that the Spanish government respond to our complaint. And the permanent representation for Spain to the European Union went back to the Spanish government and made official inquiries of them to respond to the allegations we made. And the response back from the official government response was to state that they see no incorrectness in the content of the certificate or in the application. Compare that against the actual Spanish government's website, and this is the English version of it, but they talk specifically about this point: specific transaction certificates, valid only for the holder that appears in box 1, which is not Laurel Park. If the specimen changes holder, that's the one transfer is executed, then the certificate is no longer valid. So one part of the Spanish government is saying, no, nothing to see here, dismiss the petition, and yet their official documents and their official ministry has this posted that's actually a correct statement of the law. So as we were getting ready to go up to the DFE event, we don't get out, or I don't get out much to get to Brussels, so it was a good time to try and reach out to the Commission to state that we still have this issue, it's not being complied with, and we wanted to know if they would be willing to meet with us. And we had a intermediary law firm that was doing some lobbying on our behalf, so we were getting to the right people, and they were very positive, thinking, of course we can get you connected and get a meeting. They were shocked that first the response was, no, we don't want to meet with them. We've already responded to the issue, which there were 2 issues, they only responded to 1. And again, they were not going to look at our concerns or anything because they didn't think we had any new evidence. So after receiving that response, we wrote back and said, well, if you're not going to take an opportunity to meet with us or propose a schedule that we can have a meeting, then we're going to submit this new letter alleging complaint of infringement by Spain for not following the law. And it was a short document by my standards. But it laid out all the facts you needed to know. During our presentation to the European Parliament with the DFE event, actually as I was speaking, our representative received an email from the Commission stating, if you want to complain, you have to use our form. We're not going to accept your letter form, and we'll give you until July 28th to fill out the form. So I'm starting to fill out the form. And it's they asked for it, they're going to get it. Anyone who's read the white paper knows they shouldn't have asked for the long version. But we're going to basically be claiming that the Spanish government, the Spanish CITES Management Authority, who regulates the issuance of certificates, the SEPRONA, which is the civil guard, basically the law enforcement for environmental law who need to enforce permit violations, the Spanish Ministry of Environmental Affairs, who also signed off on the previous correspondence that went back to the Parliament saying they'd have no problems with us, and to the permanent representation of Spain, which is sort of the EU equivalent of an ambassador to the EU from Spain, who passed on, I would suggest, false information that caused our first petition to be closed. So that's in the process. I've got 7 days to finish writing that, get that formally submitted. But just to make sure the commission doesn't blow us off again and that we can really pin them down, we also met with several MEPs and staff while we were up in Brussels a few weeks ago. Antje Haaskamp is from the Netherlands, who's been very active in supporting Morgan. She's done questions on our behalf before. She enlisted Francisco Guerrero, who hosted the MEP event for the GFE, Pascal Durand, Carolyn Russo. We have 4 members of Parliament who have now submitted on their own a formal written question to the European Commission. They have 6 weeks to respond. And basically, knowing we were going to be doing this formal complaint, I wanted to make sure the questions were very similar, so they were going to be very boxed in. So the MEP questions are, does the Commission agree that box 1 of the certificate identifies Dolphin Hardwick as the holder? Question 2, does the Commission agree that Laurel Park should be required to request a new certificate? And question 3, is the Commission aware of any EU certificate ever issued to Laurel Park to allow them to display Morgan for commercial purposes? It's not that they can't have her in the park, they just can't put her in shows. And that's basically where we're at in our effort of 8 years to get justice for Morgan and get the laws that are in existence. They need better laws and more laws, but this is something that already exists and is not being followed because Morgan's really the only one that's ever had someone challenge or speak up for her to this level at the European Commission. So what's next for Morgan? Stay tuned. We'll be hearing a response from the Commission in about another 3 or 4 weeks, and then we'll have to see how they handle our written complaint formally accusing the Spanish government of infringing EU law and ignoring the fact that they're allowing a private business to exploit a strictly protected animal in the EU.
Thanks, guys. I'd really like to just, in front of everybody, just acknowledge Matt. I mean, Matt is a friggin' rock star. Honestly, thousands of hours as a pro bono lawyer to help Morgan, and he's going to change the world and Europe, so thank you, Matt. We've got time for just one question, and then obviously Matt and I are around, so you can come and ask us any other questions. Has anybody got a question out there? Wave frantically because it's very dark. Oh, yeah.
So when you're successful, what's Morgan's plan? What's the next step?
Well, Matt's going to get to meet her for the first time. He's going to go and see her. We hope to put her into a sanctuary. We had already found a town that was willing to take her, that was willing to build the sanctuary for us. We had a donor back then in 2010 who had donated $1 million or pledged $1 million for us. And so we were all good to go. And then the aquarium industry lied to the judges. They stated that Morgan was too young to be released and all sorts of nonsense, that we couldn't find her family. We did find her family, our group, in association with some scientists up there. I predicted, and so did they, that she would turn up, the family would turn up at a certain time. They turned up within 2 weeks of when we would have had Morgan on location. Yeah, it's just tragic. So the plan at this stage is to move her into a sanctuary in Norway that we're trying to set up at the moment. So. It's the classic story, no sanctuary, you can't bring the whale, but you can't build the sanctuary without the whale, so circular stuff. But because she's privately owned now by this German guy who is an animal hoarder, the chances diminish significantly. Yeah, but the law is on our side.
Just wanted to add one thing about whether our actions are going to result in the immediate release of Morgan to be able to be moved to a sanctuary or not. The point of this particular law is that if they are doing this without a valid certificate, sanctions against them are mandatory. There's no excuse, there's no retroactive going back. So there's been nothing prohibiting Laurel Park from the day Morgan arrived from applying to the Spanish government to get a certificate to put her in public shows. They have never done it. In fact, they've repeatedly stated they know all about the requirements for certificates and they're in compliance with everything, but they never complied with this, and they keep using someone else's certificate. So sanctions are mandatory. They have to be imposed. That's why we're forcing the commission to acknowledge that this is just not a valid certificate. 3 reasons Laurel Park may have never applied for a certificate. 1, now that they've been caught, if they apply, they're saying we don't have the right certificate, and they're on the hook for 11 years of sanctions. 2, even if you meet all the requirements and fill out all the forms properly, the management authorities of the individual countries do not have to apply or grant an exemption certificate. It's discretionary. So as much as Spain might think everything's been fine for 11 years, why should we change? They may be listening to people like you and advocates and realizing that society has changed and say, no, we're not going to grant the exemption. So then Laurel Park loses the falsity of this, well, we have the certificate, and they have nothing. They would absolutely have to stop putting Morgan in any shows. And the third is it's a transfer, a single transfer. When Hardwick announced or made their application, they didn't list that it was going to be transferred ownership-wise to Laurel Park. They left to a third party, because we know now she was transferred to SeaWorld, and SeaWorld then sold her back to Laurel Park. So SeaWorld, I'm sure, never wanted to be in the mix of being named as part of this, going back to the original Dutch court cases. So that's the other reason that up until Morgan and the others were turned over by SeaWorld to Laurel Park, they didn't want to be part of having to explain how they got a orca, not from Dolphin and Hardwick, but from SeaWorld. So there's these 3 things that prevent them from doing that. But it's interesting. All we need to show is there's no active certificate and sanctions at the very least. And that, if nothing else, is a moral victory to show that Laurel Park has been lying all along, and that the Spanish government has been complicit in the way they've acted and responded to us. So victory can be defined in a lot of ways here. Ultimately, we want Morgan out, and this is the best way we've got to keep going on it.